And now we're on to one of my favorite subjects for bar exam essays, because the doctrines are so well defined and clear cut. And all you have to do really to analyze a Will's hypothetical is work your way down the hypothetical, spotting the issues and deciding who would be entitled to what at each point in the hypothetical. At the end of it, some instrument is going to control. This one says, what rights, if any, do Dot and Sam have in May's estate? Discuss. And then it's followed by the instruction, answer according to California law. This is a past California bar hypothetical. So we see that in 2004, May, a widow, executed a valid will, intentionally leaving out her daughter Dot and giving 50% of her estate to her son, Sam, and 50% to church. I'm not going to fight the fact that it's a valid will. If I need to talk about will's formalities, I will, but I probably won't have time for that. This intentionally leaving out her daughter Dot. A mistake I see often in answers to hypotheticals like this is that someone will say that Dot is an omitted child because she was left out of the will. But that's not what an omitted child is, so we'll come back to that. In 2008, after a serious disagreement with Sam, May announced she was revoking her will and then tore it in half in the presence of both Sam and Dot. So the issue here is revocation, and there are several ways to revoke a will. This happens to be revocation by physical act, so you need to know what the elements are. You need the intent to revoke, and you need the physical act. In this one, she tore the entire will in half, implying that she wanted to revoke everything about that will. At this point, May is intestate. In 2010, after repeated requests by Sam, May handwrote and signed a document declaring that she was thereby reviving her will. She attached all of the torn pages of the will to the document. All right, she calls it reviving the will, but don't get confused and think that means literally revival. We'll come back to that as well. Anytime they give you, though, that a testator attached torn pages or attached pages to the document, you should think about the doctrine of integration, and you should also think about how we incorporate extrinsic documents into a will, mainly incorporation by reference, and that's what's going on here. But then it goes on to say that at the time she signed the document, she was entirely dependent on Sam for food and shelter and companionship, and had not been allowed by Sam to see or speak to anyone for months. By this time, church had gone out of existence. So what we have right here is facts that go to the issue of undue influence and whether this was really May's will, May's intent going on here, or whether someone else has substituted their will for hers, namely Sam. The line, church had gone out of existence, that's going to raise the issue of lapse. In 2011, May died. Her sole survivors are Dot and Sam, and we're asked what rights, if any, do Dot and Sam have in May's estate. So let's go back and think about what happened here and what the implications are. So we start with a valid will. And Dot would love to be able to say that she's an omitted child and is entitled to an intestate share, but she is not an omitted child. To be an omitted child, she would have to be born after the testamentary instrument, and she was not. A parent is entitled to leave a child out of the will, except perhaps in Louisiana. But in most jurisdictions, you don't have to leave anything to your children. So then we see in 2008, May announced that she was revoking. She tore it in half in the presence of both Sam and Dot. So I'm going to analyze revocation by physical act here. I'm going to talk about the two elements. I'm going to use the fact that there was a serious disagreement to go to intent to revoke. That's further evidence of intent to revoke when I analyze that. Then in 2010, May handwrote and signed a document. This is not a formally attested will. Arguably, it's a holographic will. So here I'm going to want to analyze the requirements for a holographic will. She declared that she was reviving her will. As I said, this is not the doctrine of revival. It's just an English word that she used to say what she thought she was doing. She attached all of the torn pages to the document. That means that integration would work, because anything physically attached to the will can be integrated into it. But the main doctrine to analyze here is incorporation by reference. Then most of the rest of the paragraph goes to undue influence, and we'll talk about that in more detail. If they had just said that she was dependent on Sam, that would be weak facts for undue influence. But they gave you the fact that she had not been allowed by Sam to see or speak to anyone for months. Those are facts that tell you you need to find undue influence here and invalidate this will. Then it tells you that church had gone out of existence. So the issue there is lapse. And you're probably going to want to discuss lapse and the fact that the gift will not be saved. It will lapse into the estate. Then Meg dies. Her sole survivors are Dot and Sam. So let's talk about a couple of these doctrines in more detail, particularly incorporation by reference and undue influence. When a will refers to documents outside the four corners of the will, then those documents can be incorporated into the will if you meet the elements for incorporation by reference. And those elements are that the writing has to be in existence at the time of the execution of the will. This one was. It was a prior will. And she still had the physical copies of the will. They had simply been torn. The will has to refer to the document and show the intent to incorporate. That's met here. And the document has to be identifiable. The will has to describe it sufficiently. I think you can meet all those elements here, so we can incorporate that prior will by reference. Now, why am I not talking about acts of independent legal significance? Because, after all, a will has legal significance. Well, ordinarily, I would raise that doctrine when I had external documents that I could not incorporate by reference because they were not in existence at the time of the execution of the will. So I don't think I need to talk about that one here. So what would happen if this handwritten holographic will controlled? Well, it revived the 2004 document, which meant that 50% of the estate would go to Sam and 50% to church. But the facts tell you that church had gone out of existence, which means that gift would lapse. California, like virtually every other jurisdiction, has an anti-lapse statute, but it will not save this gift, because for the anti-lapse statute to work, there have to be issue. A church doesn't have issue and is not closely related to the testator, so that gift is going to lapse into the residue of the estate. And what does that mean? That means that Sam would get 50% of the estate. The gift to church would lapse. It's not controlled by the will, so it would go by intestate succession. And that means that Sam would get half of that 50%, and Dot would get the other half. Or Dot would get 25% of the estate, Sam would get 75%. But we have a problem. We have undue influence here. Now you can show undue influence in two ways. You can show the elements of the prima facie case, the statutory case of undue influence in California, or you can use the factors that are set up by case law. So the elements for the prima facie case are that there has to be the execution of influence in related to the will. There has to be an improper purpose to benefit himself and not another. There has to be an overpowering of the testator's own free will and the substitution of the desires of the influencer. And it has to be inequitable. It has to be an abnormal result. But for the influence, this devise would not have been executed or revoked if you apply undue influence to a revocation. Here it's to a gift, a devise. The factors the court uses in the case law include the testator's vulnerability. So incapacity or age, or here emotional distress, isolation, and dependency. The second factor is the influencer's apparent authority. Here it's a family member who's caring for her. The third is the influencer's conduct. They tell you here that he isolated her. He would not allow her to see other people or family members. And fourth, the equity of the challenged instrument or devise. If Sam can overpower her free will and get that original will back, he'll take 75% of the estate, as we already said. If she dies intestate, then he'll get only 50%. It's not very equitable to allow that will to be probated. Now, that's a pretty complex analysis of undue influence, right? Having the statutory elements and also having those factors that are in the case law, two separate analyses of undue influence. The highest scoring answers on the California bar make clear that both of those things hold, that those are alternate ways to analyze undue influence. Will you pass an exam by using just the statutory elements? Yeah, I've seen passing scores in answers that did that. But if you want a high score, do it both ways. But your answer on this one has to include the disposition if that will is invalid. If it was procured by undue influence and is declared invalid, that means that May died intestate. Under the laws of intestacy, the two, brother and sister, would take in equal shares. So Dot would take 50%, Sam would take 50%. This is a relatively straightforward wills hypothetical. One of the keys to success in a wills essay hypothetical is that you have to analyze every single writing in the hypothetical to decide whether it could be validly considered a testamentary instrument. Here there were only two, and the issues were pretty straightforward. We'll look at a more complex one next.